So I welcome you now to our first panel discussion, Digitalization and Cybersecurity, New Challenges to International Arbitration. My name is Niuscha Bassiri. I'm a partner at Hanotiau in Finland, Berg in Brussels, and it's my honor to sit together, to moderate together with Ricardo, this very esteemed panel of experts in digitalization and cybersecurity. To give you an introduction, I start with Merja Karhapää. I hope that was rather Finnish, the pronunciation. And she is one of the jewels of, in general, of panel discussions when it comes to arbitration, because she's an in-house counsel. She's the chief legal officer at Sanoma Corporation, managing public affairs, IPR, and data privacy. Business responsibilities of Merja are the Sanoma Russian BU, and she has a Master's of Law degree from the University of Helsinki and went also to a University of Bristol. Her special skills, as I pointed out before, will be today explored further, and Merja will give us a perspective from the side of in-house counsel, especially on cybersecurity. Our next lady on the panel is Hanna Roos. She's an associate at Latham and Watkins in London, and she has a very diverse arbitration experience as well. I would say two of the matters she was involved were, one is leading an investigation into irregular conduct of employees of a multinational pharmaceutical services company, including providing data privacy advice. Another one that caught my eye, of a very long list of experience, I have to say, and cases and matters involved, is advising on online company in relation to the merits of a potential judicial review claim against the United Kingdom to challenge data interception legislation. Hanna is equally diverse in her personality as well. You have a Finnish, a Swiss connection, a Swedish connection as well, and the list goes on. She is also the mother of a 3.5-year-old Tyrannosaurus Rex, so he claims, and Hanna confirms. We have then also Erik Schäfer, who is a partner at Cohausz and Florack in Düsseldorf, Germany. Erik is in particular focusing on the firm that Erik is associated with is particularly focusing on all aspects of protecting and commercially exploiting technology and intellectual property. And Erik's main practice is arbitration, in particular with a technical flavor, but I think flavor, that's how he put it, is an underestimation, because actually it's more than that. And Erik is a real expert on IT as well. He co-chairs the task force on IT and arbitration, and co-chaired the task force on expertise proceedings on the ICC Commission on Arbitration. Amongst other things, he was also a member of the e-disclosure task force at the ICC as well. I also should introduce you to Ricardo Gomez, who is our Rapporteur, associate at Dittmar and Indrenius here in Helsinki. Ricardo has an LLB from the University of Lisbon and an LLM from the University of Helsinki. He's part of the teams at the Dittmar and Indrenius for dispute resolution, competition and public procurement, data protection, marketing and consumer practice groups, and is also an expert in arbitration. Before I start, I wanted to put up a website, and Jarno helps me with that. We heard already now from Professor Lin Mel that we should think positively, and the website's name, and in fact, is arbitration. And what is it? And I cannot read it. Oh, no, here, sorry. Information is beautiful.net. So is it so beautiful? Because this website has also an amazing overview of the world's biggest data breaches. You see one of them is Mossack Fonseca, this one, where 11.5 million records were exposed. I point that out in particular because it's a law firm. And of course, as a lot of us are here in this room of lawyers, I wanted to point this out in particular. But this is not only the most tragical point. The other points are also that there are offices of countries, of authorities, that have been hacked as well. You see the US Office of Personnel Management, you might remember that hack, and the Korean Credit Bureau. There are a number of banks in this list as well, or these bubbles, which is a bit scary too, in my view. So we have here, for example, recently, sorry about that, I have to just, okay. Investment Bank, that is the United Arab Emirates Bank. And here, for example, we had a leak of 40,000 records, financial records. I mean, this is all rather serious, in my view. I know also of law firms in the arbitration field that have been hacked. I know also of institutions that have been hacked. We will discuss this in our panel discussion in a short while, but only this as a little warm-up. And now I join the group, thank you very much, to discuss the different perspectives. If I start now first with the perspective from the arbitrator in terms of digitalization and cybersecurity. There are different aspects and different angles one can look at it. As an arbitrator myself, I have been involved in cases where security was written with a big S and the parties insisted on encryption. That was, in my view, a very positive step. It was extremely, and still is, extremely burdensome in my view, and maybe because there are just not enough service providers out there. But it is cumbersome to get encryption of communication be secured. We have also the aspect of the technology or digitalization being considered as a fourth party in an arbitration, where everything is, not everything, but everything may have an E-equivalent. I think it was Philippe Pinsol who pointed that out already. So I would add first and foremost to that list that he put up email, and then you have, of course, also e-bundles, e-submissions, and e-discovery. There is a foray of e-equivalents for either be it now management tools or advocacy tools being used in arbitration. And then there is, of course, also the question of the equality of arms. So you have to make sure as an arbitrator that there is a balance between the parties. And we have here the point that you have a party, for example, that is very well equipped electronically and wants to use all kinds of electronic devices for presenting its case. And you have a party that is not so well equipped by it because it's a financial burden, or that there are missing expertise. There's missing expertise on the technical side. So a balance from the arbitrator's perspective has to be stricken there. And in this respect, I thought it was very interesting to look at a US court decision of 1997, so it's a while ago, where the Court of Appeals ruled that a brief submitted on a CD-ROM, while the other party was not equipped to read CD-ROMs, you see it's a long time ago, constituted a breach of due process. Now we don't have CD-ROMs anymore. I think most of the laptops don't even have a drive anymore for the CD, but we use USB keys. And that in itself also causes other problem in terms of security, because as soon as you put the USB key into your computer to download all the documents that have been saved on that, there is also a risk of security, of viruses being transmitted. Our practice in our firm is that any kind of USB key there is that we receive, we first scan it for malware, and we do that actually manually. It's burdensome, I have to say, but the other outcome would be just too detrimental. The damage that would have been caused would be just detrimental. I have also heard of a ransomware virus that was hit a law firm recently, where people in the office could see that files on their main drives, on the server drive, were encrypted as they were going on. So that was also a huge scare, because documents that were not saved on the backup disk the day before of the server, but were worked on by the arbitrators or by the lawyers on that day, were actually gone. And it took a while to get those all disencrypted, or I don't know how you call it in English, but anyway, to get them back again. So on these notes, I would like to only throw some thoughts out from the arbitrator's perspective. We will have the possibility for the audience to participate further. We will have a Q&A session now anyway, and with no further ado, I would like to give the floor to Merja, and to let her give an insight on the perspective of the in-house counsel.
Thank you. Thank you very much for having me here today. What I would like to share with you is company's perspective, what we have done to protect us from cyber attacks, and also share my insight as a client in arbitrations. Sanoma, the company I work for, is a media company, and thus first ones to undergo digital transformation. And therefore, everything we do nowadays is also done in a digital domain, even though we still do print products. But the production itself is obviously digital. Examples of incidents that we face, like any other company faces, but possibly we pay more attention to that. Examples of those incidents nowadays that we need to tackle include targeted attacks like hacking, malware attacks. Malware is a fancier name for virus attacks. Unauthorized access, so that someone from outside of Sanoma gets an access to our information or infrastructure. And what we are particularly worried about is loss of devices, because of the mobile devices so much used, and most of our staff are journalists and moving around quite a lot. And we use a lot of freelance workforce nowadays as well, and obviously all they rely on mobile devices. So we pay a lot of attention to cybersecurity, and the need to manage cybersecurity comes from at least 3 reasons. most of all, we want to avoid badwill in our customer relationships. Media company is a consumer company, and we are very dependent on trust from our consumers, but also from our advertising clients. So we want to avoid losing reputation in the eyes of our consumers and suppliers, and also obviously advertisers. And we also want to avoid damages. So it's threefold: badwill, reputation, damages that we want to avoid, and thus invest in cybersecurity. When I think about arbitration, I'm sure that the same drivers apply. There are at least 3 parties in arbitrations. There is obviously client, attorneys assisting the client, and then arbitrators. And to maintain a trusted relationship is relevant in all these relations between attorney and arbitrator, and attorney and client in particular. And the same drivers apply. I would imagine that all of them want to avoid badwill, loss of reputation, and damages. The reason why companies choose arbitration is normally the fact that the financial interest is really big. It's millions of euros, but can be tens of millions of euros, in some cases even more. And therefore, there is a great financial interest at play. In addition, normally those cases are very confidential. Companies choose arbitration because they don't want to have their disputes in public. And therefore, it's not only financial interest, it's also reputational interest that is at stake. Companies never start arbitrations without having hefty reasons. So companies expect at least the same level of IT security from attorneys and arbitrators than what they apply themselves. And then if I quickly just explain how companies safeguard their information, what we have in place is clear governance rules with clear roles and responsibilities about what data we have, who processes the data, and where the data is kept. When there are third parties involved, we take care that we annex data management rules to our third-party contracts. We train employees. There is continuous monitoring going on. We react to data breaches immediately. We also have, because it's the human link that's the weakest link, so we have issued rules, so-called 10 commandments, that are up there. Clear, simple rules that each one of our employees should always pay careful attention to. And these rules include very basic, simple stuff, but surprisingly often people do forget about these. Like, think before you click, or do not open messages or files you do not expect or trust. Like when I get an email from our CEO to arrange a large money transfer from our company to a third company, I shouldn't start doing it. And these are exactly the kind of emails that have been floating around during the past weeks. Third one, protect sensitive information. Then rules about strong passwords. Advice about being really careful when using public Wi-Fi networks. Never leaving mobile devices unattended. And that's one of the most difficult rules, because then you really have to take your mobile device from your car and not leave it in there when you park your car. Remember what you put on the internet, etc. So very practical, very sound rules that show that it really is not so much about compliance, but about secure way of working.
Right. And Erik, having now heard the 10 commandments from an in-house counsel, would those also apply to working as counsel, representing a party in an arbitration?
Well, first of all, I want to thank the organizers for having me here, because I'm a white-haired Caucasian Protestant above 50. So I'm lucky somehow the filter hasn't worked. But to move on to the topic, we are a technology law firm, and for us, arbitration is one of our many activities. And since technology is probably more prone to this kind of attack than an arbitration case, in our firm at least, our security efforts are driven by the need of our clients. So what our clients need is what we try to give them. Of course, as law firm, we are bound by the local laws concerning security, data protection. We have now the EU Basic Data Protection Directive, which we have to apply. In Germany, we have a stricter role. So we have to look for two needs. We have to look for the need of our clients to be in compliance with the law. So if they give us information, they want to be sure that we comply with the laws in regard to this information, especially if it's personal data. We have to look after their innovations, because they give us information about their innovations before it's known to the public, even sometimes before it's a product. Right. So it's very sensitive. And what do we do to safeguard all this? First of all, our employees cannot take with them any information that is in the firm. This is only reserved to the attorneys. So there are very few people who work at home, and these are the attorneys, and I'm just going to tell you what these attorneys can do. They can also not do everything. Our system is behind a firewall. We have email filters, we have a virus scan, and we have to the outside email servers that have a server that handles encryption. So if our clients want to have encryption, we have a server that sits, and if they have sent their signatures, the system directly, automatically detects the sender and the signature and decrypts. So within our firm, which is like a fortress, these messages are decrypted, but outside everything is exchanged by encryption, depending on the sender. This is automated. There is a compliance problem, not in our firm, but at the end of the clients, because the client has one employee who is authorized to use the encryption certificate, but not the others. And the clients very often within the company want to send around these messages, which is not possible if it's encrypted. So after a time, first they ask us to do it, and then they abandon themselves the system because it's inconvenient for them. We have our servers in our building. We have a redundant system. So if a part of the building is disabled by a fire or something, we can continue to work. We have data storage outside at about 20 kilometers distance. So if a bomb is dropped on our office, we can start in some 48 hours from another place. Perhaps not with everything we had, but I think we can meet deadlines, which is for a lawyer very important. We can recover everything. For our lawyers who work outside, we have a VPN, a virtual private network. We can log on our system, so when we work from the outside, we work on our servers in the building. And to log on, we have a double identification system, so you have your user ID, you have a complicated password that passes a basic test, plus we have a token that we receive for each access. But I'm not going to be too specific about this, because the more you tell, the more risk you create. Because the intruder with this information, it's recorded, somebody sees it, and then they know how to get more, they know more to get into our system. What we need to know also is that in the end, like a lock on a door, you have also clients who produce locks, and these are also electronic. They will tell you there is not 100% security. It's always a question of the budget you need to breach the security. So if you have a small secret which is not worth much, and the other side has to expend more than it's worth, they won't do it. Only for the important things where the budget is justified, they will pour in the money to breach the security. Now we can ask ourselves, and I come back to this for arbitration cases, what does that mean? A huge problem are the social attacks. You talked about it, the email from the boss. They do some research, they phone, they go to sites like LinkedIn. Yesterday I received a message that my LinkedIn account had been breached, and I already changed my password. But the social attacks are a bit big problem, and also private contacts, because these people gather information and they send messages that cause people within the organization to do things they would otherwise not do. It can also be that they copy something on a USB stick and send it to an address, and the whole thing was a fake. It's not only about money transfer that was not authorized. Yeah? So this is a broad spectrum, and of course emails which are not so clearly from a person with a clear context. It's only the email address and it says please open the attachment. It's something we send automatically to our IT people to screen it before opening. So a good rule is, before you open something that looks somehow suspicious, don't trust your scanner, because the scanners do not always detect everything.
Right.
Yeah? Send it to the IT people, if you have them, to check that in a secure environment where this whole thing cannot spread. Okay, now concerning the council perspective in arbitration. We know we have our infrastructure, we have the established procedures with our clients, which are normally long-term clients, so we can establish stable procedures. We know with whom we talk and who needs the information we receive and send back. But by an arbitration, we have an unstable system. We have no information infrastructure, we just have the net. And everybody uses it. How do we use infrastructure today in arbitration? It's mainly email with attachments. It's just, we have replaced the facsimile by email with attachments, which has many inconveniences, but it's also not very secure. Of course, we can try to convince everybody to send this encrypted, but it's probably not going to work because it's cumbersome, and somewhere in the whole line there will be somebody who's not going to use it all the time because it's just consuming, and they have to change their internal processes because they do not have the same processes we have. So what we see is there is a lack of standard procedures, there's a lack of knowledge and training on the part of arbitration users on these little nitty-gritty technical details which would make everything more secure. Now, do we insist on the implementation on security measures? Yes, if an assessment of the case, which we need to do with our client, leads to the answer that there is information in the file that for some reason has a high value and needs to be protected. In most cases, and I think therefore people do not so much care about security, probably the users, which means the parties, the clients and the lawyers, think that, okay, it's not public, but we do not need this high level of protection. And therefore they do not make the efforts. But in our field, where we talk about innovations and perhaps some arbitration between two competitors who are just leading in the market, there might be information where you need to have this additional package of security. And then you have to insist. When do you insist? You insist when you have the case management conference. And you have to take this up with the arbitrators. The arbitrators, as you all know who do arbitration, normally discharge these things on the parties. They are not very aware of these issues, and they